So, Gopal, I will ask you to follow up on that, which is what do you think would be some of the key things? Professor Menon, I think, very correctly mentions autonomy. What else do you think would be essential?
I think I need to dwell a little more on autonomy because this, I think, is really the heart of the matter. Somewhere, if one were to look at what distinguishes high quality institutions with institutions which are, shall we say, more disadvantageously placed, is the lack of academic autonomy. If you don't give teachers and professors their spaces to be prepared for their lectures and the way they should teach, the way they should actually communicate with their students, or if suppose, let us say, there is some overarching political agenda which you think the academic community must actually inflect slowly, I think it's a very serious affront to academic autonomy. One of the biggest problems, I think, which has happened is that when a university, and you can just see it from any university, take the case of, let's say, the Delhi University. Take the time when we had the greatest of law teachers, greatest, absolutely the most fabulous. I think each one of them would rank, I would say, they would rank possibly with Ronald Dworkin, or some of them might even outpace him in terms of jurisprudence or the way they walked with jurisprudence on the corridors of the university. They were such brilliant people. We used to be taught private international law as if it was like Alice in Wonderland, but it was so wonderfully structured because the person was all on top of that subject. When I see today Adrian Briggs giving a talk on private international law, and I see what that teacher taught me years ago, it looks that, well, my God, this quintessence was known to me when I had studied law under that professor. Strangely, she was the first lady to have actually been admitted to Cambridge and was the companion of Lord Leicester, Professor Lutika Sarkar, whom I remember today. But I'm mentioning that when you have, and she was one who believed academic freedom must never be mortgaged at any cost. So we had professors who actually have their own ways and styles, but nobody mortgaged academic freedom. And two, none of them actually got associated into political activities. And that's very important. When we talk about it, we must understand this. You may have political views, but the moment you become associated with political parties, you are inflecting again some kind of divisiveness in the academic community. The third is mutual respect for academics inter se. That's equally important. And the fourth is academics must actually have a space for publication, and also the students to publish along with the academics in a journal, as you see in so many American universities, right from Harvard to Vanderbilt, all of them. But there is a point, I think, which today Professor Sashikala made. It was a point in the passing, but it is a point which I take serious notice of, which is the presence of judiciary. That is not consistent with academic freedom. I want to make it clear. I support it to the hilt. I don't think that they are actually meant to suddenly come in and sit in these organizations as, shall I say, patrons in chief and so on and so forth, and have again a sphere of exclusive influence. I'm sorry, I don't think it is correct. It's not morally correct. I'll explain this. And I'm going to explain it with reference to the humility of the judiciary, the converse. You must know that the Indian Law Institute, which is a small building opposite the Supreme Court premises, was actually established because of the judges of the Supreme Court. Nobody knows why it was established. Because the judges said that, look, we don't always want to have this heavy mantle of being called judges with power and with authority. We don't just want to summon people. We want to go to a place where we can learn. We need to learn. So the Indian Law Institute was actually founded where the most eminent professors of legal thought, and mind you, the first few directors were all the most outstanding professors of law, who were the directors of the Indian Law Institute. So they would go there, and they would go in completely informal, totally normal attire, sit and actually discuss with professors of law what are current trends of thought, what are current perspectives on rights, what are current trends even in sociology, and how do we actually build up a new model of interpretation, because this is a different society. They felt they needed to be educated. But when judges actually want this way, it's fantastic. But if you are occupying spaces in a governing council or in an academic body by virtue of an office, then I'm afraid there is a certain inverseness of power. You're making then the institution itself subject to some sort of judicial oversight. I don't think it's correct in principle. I think academics are entitled to complete freedom, and they have to be treated with total respect by the judiciary. Now, what has happened is this idea of patron-in-chief. I hope there's no more about patron-in-chief, but this is not a very good way at all of encouraging. I mean, today you must appreciate that there are judges who at least have the humility to tell me, well, actually I didn't know this. It was my law clerk who found this out for me. I can't say it, but actually it was the law clerk who was brighter. The law clerk actually pulled this piece out, and I still couldn't understand, and I had to sit with the law clerk to understand. But that is what they should be about. It is the humility of learning which they carry in that office, which is going to make them great judges. Which is why even now when you see the best of judgments, you can clearly see the hands of a very good law clerk who has assisted the judge truly in helping that person to learn. It's not possible for a judge to have all the human experiences to write a particular judgment. But let's go further on academic freedom. Government must have absolutely no interference in academic freedom. Now, if you appoint a vice chancellor who has got an agenda, mind you, that's the first wrong step you take. But if you have a vice chancellor who is a man of great distinction, then in that case, you see the academic output and the growth of that university itself is going to be fantastic. And we must not forget that the best of Harvard, the best of Yale, the best of Michigan, the best of any of the universities which we have seen in the United States, what is that one thing which has actually made them stand out for themselves? It is their academic community. I'll give you a small example. I was at the IBA meeting when we were with David and his passionate, we were talking about, it was an IBA conference, and it was about, shall we say, the development of law and what is the connection between law and business, not business in the crass, crude sense, because everybody thinks that we're talking about a capitalistic road here. What really David means is capitalistic in the sense of growth, which empowers people in terms of ripple effects. Now, that's something also which needs to be clearly understood. But even then, I could see the sensitivity, and I'm talking of academic freedom, which I saw. Martha Minnow was actually presiding over that, and I could see that, her back straightened up, and I saw how strongly she felt about her own views relating to, and she said it as a part of the introduction. So look at the sheer academic freedom. Here are two of the greatest professors of Harvard, and they spoke their own points of view, and I enjoyed it. I said they were not playing, it was not meant to be an orchestra. It was actually meant to be sheer intellectually challenging thought. This is what, as Sashikala says, when she said about menu of choices, why did she say menu of choices? So that we have some diversity of opinion. We don't want the same judgment repeated over and over again. We've now heard them. We have seen them. We know those lines. We know them by heart. But you have to give new life. And for that, you need, I think, complete academic freedom. If there's one thing which I think we have to urge students to do, is to treat their professors with great respect. Number one, please just don't judge them too quickly. I'm saying it out of own experience, and I say it as a modern trend, because they seem to be in a big hurry to become judges of teachers. No, take your time, because always remember, the teacher may know and possibly knows much more than you do, and you have to give that person space and time. And that is one of the things which I wrote for one of the young gentlemen here, that if you want to be a great lawyer, it's my trade secret, by the way, I'm letting it out in the open, which is always look for something special in every lawyer. You will find it. If you find it, remember you're the richest person. The same applies for academics. Remember, students are going to be the richest when they respect their academics, because from them and the way they look and interact with them, they are going to gain the maximum. But how would then academics be positioned? Academics must feel free. They must not feel that there is a brother, someone who is overlooking them. They must not feel that they are at some contractual tenures, which are going to be simply, washed away. And the idea that I can't believe that if suppose Symbiosis said, sir, actually my recognition is going to expire in 2019 and I'll have to apply, it will look horrible. You need some stability to established institutions. And we need to give professorial and, shall we say, recognition to the academic community. If there is one community which has suffered in this country, and I'm now saying it to close the point here, I have always believed that we had the best academics who qualified under our constitution to be direct recruits to the Supreme Court. And I say it without a manner of doubt. Many of them were my teachers. I think a Professor Upendra Bakshi, a Professor Lutika Sarkar, a Professor Menon, a Professor D.K. Singh, who taught us constitutional law, a Professor Erabe, I think any one of them, or a Professor B.B. Pandey, who was actually the architect of legal aid, shall I say, and criminology, I think every one of them was fit to be a judge of the Supreme Court. And I always wondered that why is it that, is it because of their simplicity? Is it because that they don't seek out? They never sought. And that is important. I think the Supreme Court must now make a departure, and I'm saying it publicly. They must now actually, because that provision in the Constitution is still available, why they use it in the United States when they look at candidates, one of the things which they see is also the academic work which the candidate has done for a position as a justice in the court. I think that should be used. It's meant to be used. Take Baroness Hale, one example. Baroness Hale is today the president of the UK Supreme Court. She is an academic. And I tell you, her portrait is in the Gray's Inn. She has something to say for herself. She has the guts to say, and mind you, this is in a BBC 4 interview, that the way I think, my fellow judges don't think. Because I think differently. I'm structured differently. But so what? We are meant to think. We are not here simply to kowtow to each other's opinions. We treat each other with great respect, but we stand up for our own positions. If today an academic in UK is actually the president of their Supreme Court, I think we have a lot to learn from. Thank you.
Thank you. I must say, I love a panel where the bottom lines are academic freedom, more influence for academics, and more academics on the Supreme Court. I should have more of these panels. Director Gurput, I would like you to round out the discussion with your thoughts on this important issue.
Thank you, Chair. I'll be talking very quickly about what is the kind of change that we are talking about. First of all, based on yesterday's discussion, I picked up this point on therapeutic contemplative elements, 21st century skills. Why do I say this? Because earlier we had a discussion on the 21st century law school, but nobody defined what are these 21st century expectations and 21st century skills. 21st century is going to be youth-driven. It's going to be a lot of youth in one part of the world and a lot of absence of youth on other part of the world. So it's going to be a world which requires to be compulsorily connected. Now, are we preparing our youth or our human resource from that point of view is the question. Secondly, when you are preparing them at a tender age, Dr. Menon is not here, so I can loudly differ from his viewpoint and I can loudly vouch with the Raj. I revived the discontinued 3-year law program. The reason is, I myself am a product of 3-year law school, and I saw the models across the world, and I saw that our tender students at the age of 17, and by the time they graduate, there's a lot of impact which is going to be created on their tender minds. They wouldn't like to be told like this, but we have evidences. We don't speak without evidences. So we had to keep a compulsory counselor in the campus. Earlier we thought that in a typical Indian traditional way, this kid is not going to withstand, and is weak and all these kinds of labels, only to realize that our own ignorance about mental health issues was so big. So the moment you realize health as a comprehensive issue, you realize that there is a need to incorporate contemplative elements, stress-free elements, therapeutic elements into the legal curriculum. So it's about driving the future in terms of change. What kind of product we want to create to meet what kind of needs, what kind of process we follow, and who are the people who are going to drive this process. So 3 Ps. Second is the development across US, if you see, which is, I would still look up to US in terms of model legal education, as much as UK if you're looking at knowledge, but in terms of flexibility, I would look at US. The development from McBride to Carnegie clearly shows the way in which the legal education has moved, adapting itself to the changes. Indian Law Commission reports, National Knowledge Commission report, and our Gangtok Declaration in a way reflect the similar evolution for the need, similar need for evolution of legal education. So as Dr. Menon rightly put, I was also going to recommend the same, create an association of Indian law teaching institutes as a think tank, and as a forum for global and regional best practice sharing. Subsidize legal education, because we don't want our students to die with debt burden by affording these huge fees. So there should be a kind of fee regulation and fee rationalization, but at the same time, to give the access, there should be some way of subsidizing legal education with the government support, or as told earlier, some kind of fund support from the private sector or the stakeholders. Upgrade them with funds, provide value for student investment. This is the most important point. Today's student understays because they don't see a value for the investment, because of the shrinking of the law jobs or the narrow way of creating, this is a limitation in Carnegie as well. It was looked at from the point of view of creating human resource for the predominant version of legal practice, namely court-centric practice. So a wider view is required. Enriching social mobility, breaking the glass ceiling in terms of diversity in profession as well, social inequities, addressing unmet legal needs, locational, regional issues or disparity, or the kind of issues which are in the region to be in the center of the law school are some of the facets that we could look at. Auditing the law schools, self-auditing more so, and institutional social responsibility of the advanced law schools or older law schools towards upcoming and less privileged law schools is another important issue. Who audits? Faculty audits, student audits. I invite students from other law schools to my programs. Maybe they can spend a semester or they can spend some time in the law school when there is a specialized skills program at a very nominal rate. So depending on the income of the law school or status of the law school. My most emphatic point is to put the learner in the center. And in the quality focus, not to have your infrastructure and other things, but student experience. How does the student experience the law school? And research on 30% and rest 20 are about other things. So I would say skill, values and knowledge ratio also has to be very clearly determined, and all stakeholders have to be engaged in determining the curriculum. So we look at annual revision of curriculum in symbiosis. Maybe that's why we keep that cutting edge every year. I also would advise to consider the comprehensive legal skill development, the experiential and clinical learning, which was earlier emphasized. I don't want to overemphasize it again. But I would like to quickly share in 2 minutes the 2 slides, which was part of the presentation I gave before the Parliamentary Standing Committee in 2016, where Dr. Raj was also with me. We showed the background of where we were standing in terms of legal education reforms in India, from Knowledge Commission to other developments. And what we were aiming at was looking at legal research, looking at stakeholders of legal education, engaging in legal education, inter-stakeholder relationships, interdependence of law schools, mobility of students and interchange, knowledge as the key driver in terms of removal of tiers of legal education in this country and creating just and happy society or just and happy nation. Now, from that point of view, the Gangtok Declaration is a kind of document that I would urge each and every one of you to go through. We had the international level developments coming from the law teachers. So at the end, we were advocating improving access and quality of legal education and ensuring the outcome, as Mr. Gopal said, by intra and own and extramural aid, capacity building, strengthening the research ecosystem in existing institutes. So I want to just highlight, I don't know what happened, the previous slide, please. I want to highlight this slide, which is a comprehensive previous slide. It has ended, is it? Yeah, I'll do that, yeah. So this is what I would like you to take a look at. First part of institutional arrangement in terms of Indian Council of Legal Research with regional centers and approved research centers. These approved research centers could come from law schools, universities, or autonomous bodies engaged in research, which could be both in private sector, public sector, or private-public partnership. Second is capacity building and human resource building, which is looking at research fellows, professor emeritus, visiting scholars, and chairs. Third is evaluative approach, which is about reviewing the system, profession, and curriculum. Fourth is special and approved centers. These special and approved centers coming in aligning with different specializations. And then consultation, training, and extension, where we have IP and innovation in terms of intersectionality, interministerial policies and papers in terms of outcome affecting the governance, continuing legal and professional education for all tiers of human resource. Then we have faculty development programs, interdisciplinary research, consultation and training, and community legal literacy, very important part, law reform research. So how do we bring it under one umbrella in terms of Indian Council for Legal Research? Following the cue from the Indian Council for Medical Research is what I would like to leave with you for deliberation. And Parliamentary Committee has heard, and I don't think anything has come out. Hopefully Dr. Menon's addition to National Higher Education Policy would become a breather in terms of making a difference. But till then, maybe some parts of these could come into our institutions or to our work. Most important one, which I didn't highlight here as part because country is not ripe for that, which I do in Symbiosis, is credit transfers. You know, the very well-structured global legal education component coming into every law school so that we prepare for tomorrow. Thank you, Chair.
Thank you. So I know we're a little over time, but if they'll permit me a minute or two to allow for maybe one or two student questions or questions from the audience. Yes.
My question is to you, as you said that there should be independence of, as you said there should be independence of academia. So basically it would aim on the quality of education, and which is directly proportional to the quality of teachers we are having. So how come you expect the teachers of, actually the malnourished teachers, teachers which are passed from the malnourished institutions to develop a student for the 21st century institutions? So my question basically is that if the teachers are from out of those colleges which themselves have not been trained well, how can they train the students well?
Very good question. It's an excellent question. It needs an answer. First, I must tell you that life is not static and learning is not static. I don't want to mention names, but some people who almost flunked their law exams are today the brightest senior lawyers. Not me, but I'm telling you. There are many. The point is, people can actually learn and acquire skills. I've known people who studied in the backwaters of a place in Berhampur, in Orissa, but they actually worked on themselves and were first-class teachers. So the fact that they had perhaps a less advantaged background to learn their law in does not disable them from actually having access to first class postgraduate teaching and then start teaching well. It's a fact, it's a reality. So I'm sure Sashikala will also bear this out, that very often we have seen that people with completely, and when you look at their background, where did they have their schooling? But from that schooling, when you see their marks in the LLM, and you see the quality of their doctoral work, and the place where they've got their doctorate, you know they have made it. So we must know that, like all of us, and this applies, mind you, even to law students, there are people who in LLB were poor, second class, LLM gold medalists, and went right up to the top to do a PhD. So bear in mind that there is nothing called a lost point as far as a teacher is concerned. The same applies for a student also. There is no lost point for a student. There is every point of change and reformation and movement onwards. There's also a small point which I think Professor Sashikala made. It was a very, very significant point, but I want to touch on it. She said therapeutic contemplative element. I want to borrow that phrase. It is very necessary for all of you, because you are possibly in a more stressful condition in the educational atmosphere, in the aspirations which you have for the future. You're wondering what will actually happen once you get out of law school. How will you actually look after your families, have lives of independence? These are very valid concerns, which is why it is important, I think, in today's law school that we factor in that stress is not built up. Competition may be there, but competition in a meaningful sense, because ultimately I think each one is so unique that if an institution understands the importance of uniqueness itself as an end goal, I think that's a very big contribution it will be making to society. It is the uniqueness of an individual. It's not the grades. The grades are partially reflective, but still the person is over and above the grades. So it is that principal or that vice chancellor who understands that it is the grades plus the person which makes the totality. And I think that's very important. Does that answer your question?
Okay, we have time. Let's collect a couple of questions. So him and then Raj, and then you, sir.
Good evening to the esteemed panel. As a context clue for the question, IBM Watson is the artificial intelligence virtual legal assistant. It's powering something called ROS. ROS can replicate and simulate a substantial portion of the cumbersome and mundane mechanical tasks of a lawyer. So in the light of this development, how do we go forward? To Subramanian specifically. Thank you, sir.
Yes.
We'll take a couple of questions
Sure.
and then bring
Okay.
it together. Raj?
Well, thank you so much for this fascinating panel to both of you.
I want to, what we call, point out 7 issues.
Just a minute.
I
Raj is
mention
going
only words, not sentences. The legal education in India, especially the law schools concept, are missing. Focusing on post-graduation legal education. Second one is research. Third one is training. Skill development, maybe drafting skills, language skills, communication skills, technology skills, whatever it may be. Skill development includes everything. Applying technology for delivery of the legal services. Practical aspects. The last but not least, the behavioral science, that is the psychological aspects. This component should be included, whether in curriculum or standards or whatever you, the leaders of law, decides, or think of it, debate it and discuss it. So this component is very, very important. A teacher, a doctor, a lawyer, first he should be a psychologist, then he is a professional. I feel it, the psychological component or the behavioral science should be included in the legal curriculum. So I request the panel to react.
Thank you. Raj?
All right, I'll keep it very short. The thing is that I was just wondering why the legal community, particularly the lawyers, have not yet seen the importance of seeking reforms in legal education. Because lawyers are very obviously conscious of judiciary and its impact, something happens there, there's an immediate impetus. For a while we have been talking about the crisis in legal education, but there is so little agency that is emerging out of the legal community. And the same is true for the academic community too, that we see this, continuing crisis within legal academia, but why has academia collectively not responded adequately to this crisis?
And last question back there.
Hi, my name is Ajinkya. I'm coming from Bombay to attend this conference. One question which is a bit out of curriculum, I just wanted to ask, especially to Mr. Gopal. Gopal sir, like you were the chairman of the Bar Council of India. I wanted to ask you one thing, that why doesn't the Ministry of Law and Justice as well as the Bar Council of India come up with a bill which will raise the standards of a new national law schools which will have a prospective effect, not a retrospective effect. I belong to Maharashtra. There are a lot of upcoming colleges which are hardly like not even 10,000 square feet. They are opening a law college in that. So most of them don't have libraries, most of them don't have labs, most of them don't even have classrooms. So why is India not coming up with a bill to raise the standards of the legal education? Like what for engineering, there are proper aspects, then only you get the permissions to take the courses. For medical, there are medical councils like that, something like that.
Excellent. So I'll leave it to the panelists
Okay.
to answer. I don't know if...
So I
would
think
like-
I'll answer a couple
Okay,
and then I'll leave
please.
Let me start with the last one, which is about a bill. I think the standards are actually specified. You must know this, as a matter of fact, which Professor Sashikala mentioned. The Mitra report, and actually I was also a member of the committee. In fact, it was my report as Solicitor General in the Bonifoy Law College. That was accepted, and then later they passed a resolution. The point is that you have standards, but the point is you have to implement the standards. If you just look at a modern law school, you look at, say, I'm not saying, look at Jindal, look at Symbiosis, you look at Sydney Law School, you go and just go into their classrooms. You actually would like to sit down and study there without anything more. I mean, I hope it's an invitation, Professor Wilkins. If you invite me to your classroom, I'll sit down and study. Because the point is that the place entices you to study. Now, if you have cattle sheds, and I'm very sorry to say this is the point we have. We have vested interests. We have politicians who want actually some sheds to be recognized as law colleges. Now, surely we can't. And I think it's too serious a mistake for anybody to make to actually recognize institutions like this as law colleges. Two, when you said prospective effect, no. Existing is equally important. And should I tell you, you don't need more and more and more and more and more. You actually first must know what you have. And what you have, and if you know, if you have gone to New York, I want you to look at what's called that Apple store on that 5th Avenue. It's one of the most beautiful stores. I promise you, you don't need so much of space. You know, if I were to merge 11 law colleges, and I did with an architect, you just needed space like an Apple store and you would have the best law college. You needed an equal space for housing them. You could give them the best of place for their physical activities. This needs some imagination, some goodwill, and some positive thinking. But it must apply, in fact, to the existing lot. Then I go backwards, because I must allow Professor Sashikala to place a point of view. The point which Raj made is, why is it that the legal community is somewhat indolent and is actually not stepping forward, understanding the seriousness of the situation? This again is because of a discontinuance of tradition. You must know, Raj, that earlier, and I'm giving this as an example, this applied to Bombay, it applied to Pune, it applied to Calcutta, it applied to Delhi. I'm giving you 4 places from personal knowledge. The best of lawyers used to go and teach in the law college. You must know who were the people who went and taught here in the law college as part-time professors. The part-time professors were lawyers. And whom were they selected by? They were selected by a committee which was presided over by a judge who had a doctorate as a qualification. So imagine It was a Dr. Bijan Mukherjee who selected, and on that day there were 3 people who were selected. Professor P.K. Tripathi, my father, and Dr. Lutika Sarkar. My father was a part-time lawyer, but he went and taught in the law faculty. Then later, you had lawyers who were regular practitioners who devoted a certain number of hours in the week, and they did it honorary. They did not do it for a fee. They thought this was something which they had to give back to the academic community. Now, if this was done even today, please take it from me. It is something which I think the bar must do on a voluntary basis, whether it be in Maharashtra, whether it be in the interior. And I promise you, when I spoke to actually some of the members in the Maharashtra Bar Council, they're willing. We just have to coordinate and I think make that happen. The point the gentleman made, yes, all of them need to be incorporated. The behavioral science is indeed the most important, because a lawyer must know that calmness, patience, and a lack of ego are very important when he deals both with the client and with the court. His anger may cost his client, and that's very, very necessary. Lastly, the point about IBM. That's very frightening. We will all be out of business if indeed Ross were to actually do the job. But this is again, I think, overstated. The fear is overstated. Actually, this is going to perfect your skills. If you were to know, it is really going to reposition you in realizing how good is your work. Because it's like using templates and technology. Sometimes templates and technology can't still take away your genius. Just like the typewriter could not take away the genius of an author. Similarly, I promise you, no computer can take away the genius of a really good lawyer. But what is wonderful is these questions are asked. These questions, like what Raj asked, is one which demands professionals to be accountable. They should not simply roll over the money or the currency notes. It's not the money which should matter to them. It must matter to them that there is a future in the profession which they're leaving behind in the community of law students to whom they're accountable. Thank you, Raj. That's a very good call of conscience which you did strike. Thank you also for speaking about the computer, but this is to actually disabuse you of any possible fear. And thank you again that standards can easily be maintained by existing institutions. It requires a determined willpower. And that can come, I think, at the moment only by peer pressure, because we don't have really a very good existential regulator. Sashikala will answer better.
Thank you. Yeah. So, the first question on malnourished teachers, I just wanted to respond saying that the latest neurological research and neuroscience talks about neuroplasticity. So we can alter the nature of our brain, our behavior, our potential. Shall I repeat? The neuroplasticity is a reality which is scientifically proven now. So we can change ourselves at any time, our behavior, our motivation. So as long as you're motivated and interested, you could always learn. Your law school, whether it is a 3-tier law school or 4th-tier law school or 1st-tier law school, doesn't matter. It's how you drive yourself and become a knowledge entrepreneur by setting a goal and then learning. Self-learning is possible. Second is about the question raised about Watson. Watson cannot feel. That's his limitation. So we can feel. And it is your empathy which is going to never be, which will never be replaced by a machine. So for a lawyer and for any professional who is engaged with the knowledge in service of public, I think empathy is something that is an indispensable capital. I don't think any machine in human ingenuity could replace that. So learn how to feel, learn how to expand yourself in terms of consciousness as well as in terms of your commitment to justice. So I agree with Gopalji when he talked about pressing the machine into service, the complementarity of the machine. The 7 issues which were raised by a learned colleague, I mentioned it because within the limitation of time we couldn't probe into each of the details, but we invite you to some of our workshops which we do, Professor Purvi, Raj, myself, under the stewardship of Dr. Menon. Very often we'll be happy to have you on our address list and invite you to these. We do take care of postgraduate research and teaching, training in skills. Recently we have come out with a comprehensive curriculum in kids based on various workshops. So I just mentioned in that model about that. Somebody asked, I think Professor Raj, why lawyers don't seek reform, why law teachers don't seek reform. I think lawyers may not seek in a public forum, but lawyers have contributed to the academic reforms which we have made in terms of being part of the curriculum review committee. Lawyers have done it in different occasions that have been available to them. I think legal education reforms, they could do better because they are the ones who are using this human resource in turn. So if law schools do not engage them, they could volunteer, I suggest, and take pride in being a teacher. Ram Jethmalani sir, who is our professor emeritus, always says, I'm a lawyer for 54 years, but I'm a law teacher for 55 years. So that kind of pride I never saw my good old Mofussil Law School lawyers taking, who were coming to teach, who were coming with a bare act in the hand and reading out from the act. That's the kind of legal education I received. But what I mean to say is that there is a very strong symbiotic relationship between all the stakeholders, whether it is the judiciary or the lawyers or the industry. I think today the lawyers do not participate or the law schools do not engage them enough, or academics do not engage, is because of the unawareness. I feel we don't have good research which shows the success stories of their engagement and the failure stories of disengagement. I think that knowledge gap requires us to come in with structured research, the curriculum research per se, in terms of curriculum development and reviews. The last point is about the bill, about raising the standards of existing national law schools. I agree with that, and in second generation law reform discussions, we were party to the discussion. But I feel rules exist. You can take the horse to the water. But what if the horse doesn't drink the water? So we have had that issue in the sense of we have the best of the rules available within the current Bar Council rules itself about standards of legal education. Today, if I go and measure the compliance to that rule, I'm sure most of us are guilty of not complying to the T. Like about 80% compliance, 90% compliance, in some cases 20% compliance. So there is a degree of compliance. So self-regulation, as Dr. Menon said, is the best way. Unless our customers, I put the power on my students, my customers. Unless my customers, I use a very business-like word, because I believe in the power of choice under the consumer law. Unless my consumers are aware and they know and they come and check before they make the choice of signing up for my law school, I will not become alert. No amount of regulation is going to make me behave well unless I am aware that my customer is a well-informed customer. So the power lies in the hands of our students, our parents, who have to make proper assessment before they sign up for a law school. Is this law school complying with all the requirements which are mentioned? Because Bar Council regulation is available in the public domain. So many parents are also not aware of how to make these choices, especially in undergraduate programs. Many students are not aware of becoming good customers. So this is where the problem is. Therefore, I feel self-regulation is the way. Leave it to the consumer, and every law school administration and regulator should put that consumer in the center. I think that's where I see the change becoming really meaningful for our democratic setup.
Thank you. And as an end note to that, for self-regulation and autonomy and accountability, part of that is making information available about how schools perform and what they do. And part of that, of course, is events like this that bring the issues to the fore. I'd like to thank both Mr. Subramaniam, Director Gurpur, and of course Professor Menon for this fabulous panel, all of you for your wonderful questions. I'm sure you have many more. Feel free to do so when we're around. But please join me in thanking our brilliant panelists. And I'll hand over the floor to Professor Wilkins.
And please thank Professor Khanna, who, as you see, has done a magnificent job here. And for those of you, again, if you've seen our book, it would never have happened without Professor Khanna, who has just done a remarkable job at everything he's done here in India. Listen, this has been a remarkable day, a remarkable, really, 2 days. When we wrote the book, we wanted to start a conversation, and I can't imagine a more robust conversation than we've had here. I can't end this without thanking Brian Fong, who you've seen around in the back of the room. He is more responsible than anyone for everything that we've done here today from the Center on the Legal Profession. I just want to thank all of you, particularly the students. I'm so impressed of how many students were here, how many of you gave up your Saturday, how many of you traveled such a long distance to be here. Even more than our amazing panelists and even more than everyone else here, you inspire us to know that the future of India is bright. And thank you for sharing it with me. Let me bring President Testi here to bring the meeting to a close. Thank you.
Thank you all so much. I'd like to just ask all the LSAC staff who are here to please stand and join me in thanking them for their great effort and all they do in our organization and for helping bring this event about. Thank you very much, colleagues. And I want to also thank Raj Kumar and the Jindal Law School for the great hospitality and arranging a number of meetings for us while we've been here, and just congratulate you on your 10th anniversary. It's wonderful to see that progress. And I also, of course, thank Harvard Law School. It's wonderful to be partnered with you on this program, and I'm just so thrilled with all the conversation. And in closing, I want to say that one of the things that I've always done as a dean and professor is anytime I've been a little bit torn about, like, what's the right next thing, you know, in making decision, what I always try and do is come back and ask the question, what will be good for students? And really to center on students, because they are the young people of the world, and the world needs justice in the future. And so in that large sense, that will bring law toward justice. And they're also why we do this, that role of education. And so as we leave today, I thank the students for being here, and I urge all of us as we continue these discussions about legal reform and reform of legal education. And I have to say, I was so struck by how much we should have this conversation in the United States as well. This is exactly what we need to be talking about. So let's remember our students, and let's all continue to work in common cause to bring law ever closer to justice. Thank you so much.